Now, we'll call the next case Snyder versus, Biller versus State. And Ms. Catman, now you can see a couple. Is this what you'll do in a few years? You'll end up looking like Mr. Cushman or Ms. Phillips here. You'll be all, tired and drawn. They started out young and wide-eyed. That's right. Do you have your proof of insurance with you?
Somewhere, I swear it's there in the truck.
Would you like to argue from the table there, Mr. Cushman?
I would, Your Honor, if it pleased the court.
That'd be fine.
That's
nice to see you both again.
Thank you. It's nice to be here. Your Honor, I'd like to reserve 5 minutes for a response.
All right. Since you can't see the clock, I'll make sure that I give you a signal.
Thank you.
Whenever you're ready, sir.
All right. If it may please the court, Your Honor, I'm going to take the issues in reverse and deal with issue 3, which deals with count 51, the charge of transmission.
Is that an F3 or an F2 or what is that? Is it
F3?
It's an F3?
Yes.
Okay.
And it's our position that when we filed the C4 motion, the state filed a response, but there was really no factual dispute with what we alleged. And the state said that simply having Biller's computer on the internet thereby made it possible for the sheriff's computer to go to Biller's computer and download items in Biller's file. And the detective said this happened automatically without either the sheriff or Biller necessarily being aware that it was happening. And they said that because...
Well, he had to check a box, though, when he signed up for LimeWire that authorized
well, that's
people
what
to get
the
in there.
detective said, Your Honor.
Well, that's the facts that you're dealing with, right?
Oh, it is definitely facts. On the other hand, I asked the detective, had he read it? I've never read it. I don't know. And they didn't really introduce that checking the box into evidence anywhere. But simply because someone says, yes, you can go get it, I don't think that qualifies as the volitional act that violates the Florida statute as a felony. Simply because the sheriff's office had a computer that automatically went to Biller's files and downloaded some images, I suggest that is not the volitional act.
But what the statute says that it's illegal to transmit, which is defined as the act of sending and causing to be delivered. So I guess the question becomes, in my mind, is allowing something to be retrieved from your computer the same as sending it? From a standpoint of statutory construction.
I think that is the issue, Your Honor, and our position is no, it doesn't. I think it requires Biller to have actually intentionally done something, not simply have his computer on and being on the internet, whereas clearly the sheriff was able to do it. But I don't think that the fact that the sheriff was able to go to Biller's computer and download something, I don't think that complies with the statute.
Does it make any difference if that's the way the system is designed? My example, I suppose, would be this. I don't have these skills, but let's assume that I had the skills to hack into your computer and download something that might be considered illegal. Is that different because you didn't make that available for the world versus a file sharing system where perhaps you don't affirmatively send it, but you in essence leave the door open so anybody who wants it can retrieve it? Is there a difference there?
Not any significant difference. I mean, the way I read the statute, I think it requires an intentional act by the biller to transmit something to someone else. Not that it's there available for retrieval by someone else.
So you think the act of sending means an affirmative act as opposed to affirmatively leaving the door open so that anybody who wants it can take it?
Yes, sir, I think there is that difference, and I think it does require an intentional act to commit a felony. That seems like a minimum that ought to be required. Not just that someone could come look at it. It's like having a gun on your desk. Someone could walk in, take the gun, and commit a crime with it. But that doesn't mean that the person who owns the gun intentionally intended that that crime would be committed.
Well, how about if the person that owned the gun, let's say the gun was in the workplace and in the person's locker, and the person told all of his or her coworkers that, look, there's a gun in my locker. You can use it if you want. The locker is unlocked. Would that be different?
I think it would be different because the fact that there may be a gun in your locker doesn't say that you're volunteering and you intend for a crime to be committed with that gun.
Well, okay, let's make it more analogous then. Let's make it pornography. Hard copies of pornographic images are in the locker, and the owner of the locker lets everyone know in the workplace that these pornographic images are in there, and if you want to look at them, my locker's unlocked. Is that tantamount to sending the materials to the co-workers?
No, sir, I don't think it is.
All right.
If you went, retrieve the porn from the locker and say, hey, look at this,
Right.
That's, I think, tantamount to the transmission.
So you're saying that's not sending.
No, it's not.
That's just inviting somebody to.
Yeah.
It's something different than sending.
Yes, sir.
Right.
It
Okay.
is.
All right.
And I think the legislature, if they intended the statute to be interpreted the way the circuit court did and the state did, I think they could have easily said.
It might be delivery.
Sir?
It might be it might be delivery, but it isn't sending. And the statute requires sending and delivery.
Well, I don't think it's either.
Okay.
But yeah, I think that with your analogy, yes, but it is not the transmission.
Right.
Right. And going on to the other issue, which is we filed a motion saying that when the legislature passed 827-071, it was passed in 1983, and the internet did not exist, and the definition of possession was what we all understood. We understood the word possession in 1983. However, with the advent of the internet, now the state was trying to shoehorn the word possession to include something on the internet, which is really essentially electronic images, electronic items that we can no longer, we can't hold those images.
Well, the fourth district case supports their position.
The fourth district case does support their
So you suggest that we should conflict with that?
I think definitely you should conflict, and I'm proud for the fifth to not have reached further than was necessary, because the fourth did. Because then I think this court, and logically you have to wonder, well, why did the legislature amend the statute in 2011 after Biller was charged? What's the point of amending the statute unless it was inadequate? It didn't really cover what Biller was charged with.
But the amendment, there's a difference between possessing an image on a hard drive and intentionally viewing it on the internet, right? As I understand the amendment, and I understand that it changed, it included electronic data and things like that, but part of the amendment talked about this intentional viewing concept. And if you surf the internet and you look at these images, that might be intentional viewing, but it isn't necessarily possession until you download them, right? Isn't that what the amendment does? It really broadens the scope of the statute? Not in terms of the nature of the image, which is contraband or illegal, but in terms of the manner of viewing the image. Now, pre-amendment, you had to actually download it for that to be possession. Now, if you view the image and the government can prove you viewed it, even if you didn't download it, it's encompassed, right?
5 minutes left, Mr. Christian.
All right, thank you, Your Honor. Your Honor, I think that the definition of possess was actually changed by the amendment, and that under the 2011 amendment, that there may have been a crime committed. But Biller, as he said, when he viewed, he deleted it. Whether or not it ever actually got to his computer hard drive, apparently it did, but that's the purpose of deleting it. And so I'm suggesting that he was not, in fact, in violation of the 2010 statute. Perhaps he was in the 2011, but that's not when he...
Well, but he possessed it. That's what I'm curious about. In other words, the analogy in my mind is that if he had, again, hard images, printed images of this pornographic material, and he discarded them in the trash, and the police came and took the trash away, he has no longer has the ability to retrieve the images, and the next day they come and arrest him for possession. He did possess it, and they can prove that he possessed it. Why can't they charge him with possession?
Well, because in your analogy, you're talking about having printed the images. Mm-hmm. When he printed the images, he could hold them up, look at them, and say, that's good. That's what I was looking for. But when he puts it through the shredder, he can no longer retrieve it, and he no longer possesses it. So that when law enforcement comes and charges him with those possessions, he no longer possessed it.
Well, but the fact that they could prove that he did possess it, there are 10 witnesses who testify he possessed child pornography yesterday. Yes, it was put through the shredder today, but if they have adequate proof, if a jury believed it, could they, the fact that the images no longer exist or no longer in his control because he burned them, puts them in the shredder, whatever, can they prove that at one time he possessed them, and that would that be enough to violate the statute?
It would be if the images fit the definition of possession at the time. That's why the state, when they amended the information, they had that. But our position was that possession of the images supposedly on somewhere on the internet did not qualify. And that's where we're saying he never possessed.
You've got 2 minutes left, so
thank you.
I'm sure that Ms. Phillips is going to say something you might disagree with.
I think so.
Okay. You probably want to hold on to that.
May it please the court, my name is Ann Phillips. I'm here representing the state of Florida. It's the state's position that Mr. Biller did possess child pornography.
I'm more interested in his scent argument. Would you address that first?
Yes, the defendant, in order to transmit the child pornography in this case, specifically agreed to the terms of LimeWire. In order to download that and put it on his computer, he had to agree to those terms. Otherwise, it wouldn't have downloaded on his computer. The state had evidence he had been utilizing that.
Let's assume that we agree with you that if you sign up for LimeWire and you put certain files in your shared, whatever they do, that it's out there for any other subscriber to LimeWire to look at it. Okay, we buy that. The question is whether leaving the door open on your filing cabinet constitutes the act of this. What it says is that transmit means the act of sending and causing to be delivered. So I'm assuming that there must be two pieces to that. Number one, you have to commit the act of sending. Is that an affirmative action, or is that simply leaving the door open on your filing cabinet? And number two, it requires causing to be delivered. One requires an act, and one requires a result. You have to affirm, does it require an affirmative action to send and then making certain that it was delivered?
It's the state's position that it doesn't take the transmit button that the defendant has to send it. When you look at the facts as a whole, he's got the mints on the counter that he knew or should have known people were going to take this. That was the sole purpose. That is the entire purpose of LimeWire. That is the purpose of keeping files.
The entire purpose of LimeWire is not for people to download pornographic images.
It's to share.
Lots of stuff on
It's to share files.
Did the defendant in this case have other LimeWire acquired files other than pornographic images?
There's no evidence of what.
You don't know that?
No.
Isn't it analogous, though, to me having a desktop in my office that has contraband on the hard drive, and me telling my co-workers that, giving them the password? Isn't it analogous to that? So they can go into my hard drive and look at the contraband? That's
not the purpose of you having a computer on your desk, though.
Well, I mean, let's say that all my co-workers know that I've got these images on my hard drive, and I give them the password to the computer. Is that sending?
I would say no, it's not sending.
Isn't it analogous to
I would say no, because in order for people to be able to download, the defendant had to take affirmative steps of signing on to his, not telling somebody else. He had to sign on. He had to sign into LimeWire. He had to leave those images available in his shared file. And that's what changes that, telling someone that it's there and actually you taking the steps to make it available. If he was not signed into LimeWire, if he had taken those out of his shared file, there was no way the sheriff's office could have gotten in there. Nobody would have known that those existed. He made those, he put those there for that purpose, and based on the specific nature of LimeWire, he knew or should have known, which is what the statute requires, should have known that those were to be transmitted, that those were going to be taken and moved. So in that sense, he did cause those images to go. Did he hit a send button? No, he didn't. But based on the totality of the facts, the state had the ability to prove, and again, it's a bare prima facie case in a motion to dismiss. So he ended up pleading. The state could have put on additional information at trial.
What do you think the word send means in plain English?
To deliver.
You think it's synonymous with deliver?
Well, then every time I give something to the post office and it doesn't get there, did I not send it? I mean, if send means deliver, if I mail you a letter but it doesn't get there, that doesn't mean I delivered it.
And then again, your analogy would be closer. your analogy would be closer because you made it available to be delivered then, and so you've sent it.
Well, but, you know, I'm having a hard time thinking that send and deliver are synonyms, or
To
They define
make
it.
available for delivery would be to send,
but I'm
In that-
assuming it's different things because the statute says it's the act of sending and causing to be delivered. So I'm not sure it would be a violation if I mail you an image, a physical image of child pornography, but fortuitously the mailman loses it and it never gets there. Since the statute requires sending and causing to be delivered, since it wasn't delivered, have I committed the crime?
no, but here the sheriff's office got the image. So he did transmit the image, so
sending
he
and
got
delivery
it.
are apparently two different things.
So in this instance, it does include receipt, and the sheriff's office received it. And they knew that it was child pornography upon receipt. So if it got scrambled in the mix and you couldn't tell and it came out looking like a picture of a puppy dog, then you didn't transmit child pornography. Here, he did. It was there, it came through at the sheriff's office as a pornographic image of a child. So,
Now, maybe I misunderstood the testimony. I thought, and actually I thought that the testimony was more favorable to the state than what you have articulated. I thought with LimeWire, that the subscriber had the option of checking a box that manifests an agreement to share, that they could download irrespective of whether they checked the box, but the checking of the box is what allows sharing the files. Is that
yes,
the evidence?
and putting the file in the shared file. If you empty your shared file, then there's nothing there to
I thought
share.
if you check the box, everything's in the shared file. I mean, everything that remains in the file. I mean,
Yes.
obviously, if it's somehow destroyed or deleted, it's not accessible.
He would have to take an affirmative action at that point, yes.
So I'm sorry, go ahead, Judge.
Well, what happened in this case? I thought that there was all this discussion about the difference between deleting files and the file
Caching.
being in the slack portion of the disk, and I thought that he had deleted the file, which put it over into this slack portion of the disk, so that unless you had the special software that the sheriff's office had, if I had been subscribing to LimeWire, I couldn't have gone on there to get the image.
Now, my understanding of the facts is on the date, I want to say it was March 10th, that file still existed on Mr. Biller's computer, on his LimeWire account. But between when the sheriff's office downloaded the image and when they executed the search warrant 8 days later, between that time, he deleted that image. And so when they went to do the recovery after seizing it, at that point, it was in the unallocated space, but they could prove that it had been accessed and downloaded on his computer.
In my locker scenario, you heard that hypothetical, right?
Yes, Your Honor.
Addressed with Mr. Quigley. If it said, if I told my coworkers that these photographs are in my locker and that I don't have a lock on it, and that, they can go in there and look at them if they want. First of all, is that analogous to what happened here?
I mean, it's analogous, but it's, again, when you get into the data world of the computers, and you don't have to have a physical action of going, again, we're sitting there and we're connected through this computer, through this LimeWire, because we're both at that, both in that. I think that's going to distinguish it in that sense, based on just the nature of a peer-to-peer
Right.
file sharing
Okay,
program.
so you say it's not analogous. The second part of my question is, if it is analogous, is the locker scenario sending? If one of the coworkers goes into the locker and gets the images out of the locker, did I send them to the coworker?
I would say no.
Okay.
So, Your opinion would be that the act of sending is the equivalent to allowing someone to retrieve from your computer.
Yes.
Okay. I mean, that's really what, I guess what it comes down to is if I allow my computer to be set up so that others can retrieve something from it, then that's the same as an affirmative act of me hitting the send button and firing it off to you.
In this instance, yes. Your instance with the hacker, I haven't set things up for that person. Therefore, I would say the person who owned the computer that was hacked did not send because I didn't take these certain affirmative steps knowingly to provide that information to someone. That was somebody coming in. But when you put the mints on the counter, when you open the door, when you put out there, and you should know or should have known somebody is going to come take those images, that the sole purpose of that being there, yes, in this instance, based on what the protection that's provided based on child pornography, I believe that Mr. Biller did transmit child pornography in this instance.
Does the fact that we're having an extended discussion on what sending means and that sort of thing implicate the rule of lenity? Which means he ought to win simply because reasonable minds might differ on whether it requires an affirmative action, a passive action, or no action at all.
The state would say no, that it is clear at this instance that he did transmit based on the statute, but the rule of lenity does exist and certainly does what Your Honor said. But again, we would also say that he possessed the child pornography and that the subsequent amendment to the statute about possession of child pornography does not affect the constitutionality nor Mr. Biller's actual possession of the child pornography on the dates in question. If there are no additional questions, the state would ask that you affirm.
Thank you, ma'am.
Thank you.
Mr. Cushman?
May it please the court, I think that if the legislature wanted to prohibit what happened in this case, it could have easily said it would be a violation of law to allow someone else to come into your computer file and get the images that may be in yours. That's not what the statute said. I think that the statute to be violated would require a biller to intentionally transmit the image to someone else, not that it could.
What do you think the word send means, just in plain English?
I think the word send in this context would be like an email where if you want to send out, you click send and it goes out. That's an intentional act and that's what should have happened. And I think that to allow the state to generate something along this line, a felony, based on what actually happened, where the sheriff's computer went into the biller's computer automatically, I suggest that that is not the violation that should take place for a felony to be violated. And I also suggest that the possession, as contemplated by the 2011 amendment, did not qualify Biller in 2010 to violate the statute. Just the state wants that to have happened, but the fact that the state amended it, added these definitions, was a clear indication that it did not cover the actions of Biller in 2010.
Mr. Cushman, we appreciate the argument. Thank you both. We'll take a short recess while we change panels and we'll invite counsel to join us in the lawyer's